One. So, Mark, just make do with this one. Thank you, Michael. Oh, I've done all that from the pull sheet.
Good afternoon, ladies and gentlemen.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
Good afternoon.
Good afternoon, Your Honor.
We'll get started.
Judge, if I could, before we start, if I could introduce a new attorney in our office.
Who's speaking?
It's me, Mr.
Oh.
Derek. How are you, Judge? Good to
Hi,
see you.
me, Mr. Howard. How are you doing?
I'm great.
Good. Who do you have?
Miss Rachel Abdan is a new attorney with our office, and she'll be covering the first appearance calendar with Miss Kim.
Okay.
So just wanted to make the court aware of that, and we're happy to have her aboard.
Yes, and say the last name again. Abden? No.
Yes.
Yeah.
Abden? Okay. Correct me if I get it wrong, because if not, it'll stick and you'll always say she mispronounces my name. I'm
No,
still trying to learn some of the others, so everybody bear with me. I am from Kentucky. Good to have you aboard. All right, if we're ready to get started, we will.
Okay,
Again.
and also, Your Honor, the reset
Yes.
date for the SAT calendar is going to be September.
Wow.
September already, September the 5th.
September the 5th, right after the holiday. All right.
Yes.
September the 5th it is. All right, ladies and gentlemen, we're going to begin our Fulton County State Court Expedited Accusations calendar. And this is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and the cases have been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge. So we're going to address several matters, and we are able to address these matters, which include bond, possible arraignment, and a possible plea offer if one has been made by the state at this juncture. I want to begin and advise everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. Govern yourselves accordingly. I want to remind the defendants on this calendar that you have certain constitutional rights. The first being that you have a right to representation at this juncture of your case, And most of you should know who your attorneys are by now. You also have a right to remain silent. Remember that anything that you state about the facts, the circumstances, or the occurrences of your case can and will be held against you. The state is here and they are listening to you. So listen to your attorneys. Who do we have first, deputies?
Your Honor, position number 15.
All right. Okay, I will not try to again mess up anyone's name, but this is 23 CR 005141C, and it's charged with 1 count of stalking. I usually don't ask defendants to pronounce their last name, but I will not do that. Pre-trial.
Judge, my internet had disconnected for a moment. What's the position name?
I'm sorry.
My internet was disconnected. I did not hear the name.
Oh, I did not say the name because I cannot pronounce it. Position 15, it looks like Shringranesha of
Yeah.
some, and I apologize, sir, for mispronouncing your name.
I'll pronounce my name. My name is, last name is Sri Ganesha, first name is Silat Roy.
Okay, Shrignesha, okay.
First arrest,
First arrest, all right.
yes.
Thank you. State?
Yes, Your Honor. This incident has actually been an ongoing occurrence. The incident culminated on August 20th of 2023 at around 12:45 p.m. at 315 Eagles Pass in Alpharetta. Ms. Paula Fisher, who is the victim in our case, stated that her neighbor was recording her and her 12-year-old daughter, IF, while they were outside gardening. Officers were actually able to observe a cell phone that was pointed on this second-story window of the defendant's home, which was facing the windows of Miss Fisher's home. So it appears that there was some attempt to record into her residence based on where that phone was positioned, and the officers did take pictures of that and collect that on body cam. The officers then made contact with the defendant, who claimed he was recording on the property line because he observed Miss Fisher and throw a weed into her property. However, again, the officers were able to show that cell phone on the second floor was not pointed at the property line, but rather into Miss Fisher's actual residence. The defendant did claim that he wasn't recording from that second story window, but he also admitted to placing the phone in the window pointed at Mrs. Fisher's home to scare her, and furthermore admitted to opening his garage so that she knew he was watching her. This has been, as I stated, an ongoing occurrence for the last 3 years. The defendant has been surveilling Miss Fisher on a regular basis using his cell phone and using video. She has applied for a TPO that was denied, but my understanding is the defendant was heavily advised to stop the activity that he was doing, the harassing activity, and continued to do so unabated, which has led to this charge of stalking. I would like to point out that the Solicitor General's office, sorry, forgot where I was working for a moment, actually took out 2 warrants for stalking. We did 2 charges on the accusation that we filed, one involving Miss Fisher and one involving her child, IF, who is also being surveilled by the defendant. And both are very concerned and afraid for their safety due to this ongoing siege that the defendant has undertaken against them. We do have Ms. Fisher here, and I believe she would like to speak with the court. My understanding is that the defendant has lived in this country for the last 5 years, and has recently received his, and I may be incorrect, but has maybe recently received his citizenship here. I will ask.
I'm going to object at this time. I'm not sure what this information has to do regarding a bond, his citizenship status, or anything.
Actually, that would go to the Ayala factor regarding flight risk, Mr. Githia.
He's a citizen.
Right, but he has been in this country for less than 5 years.
That's not correct.
Then you are more than welcome to rebut that at your presentation of the facts, Mr. Githia.
Again, Judge, I would just object to the state bringing in the fact about his citizenship, how long he's been in the country.
And Your Honor,
Okay,
again, I'd like to point out that goes to the Ayala factor of flight risk and ties to the community.
All right, go ahead, Deputy Falk.
The state is asking for a $10,000 surety bond, $5,000 per count. We're asking that the defendant stay 200 yards away from Paula Fisher and the minor child IF. No email, messages, phone calls, third-party contact, or social media. No video surveillance, and no alcohol, drugs, or weapons. We would at this time like to sound for Miss Paula Fisher.
Tell me what your second charge is. I only
Again-
see one on the,
Yes, Your Honor. Both
or
were
2
charged-
counts of stalking.
Yes, Your Honor.
I'm sorry,
One for
yeah.
Miss Fisher and one for the minor child IF.
Right, 2 counts. I got you. Okay, thank you.
Your Honor, on our paperwork, we only have one. It's only one.
Is the other file?
Yes. Your Honor, there seems to be a little feedback. There have been some ongoing issues with Odyssey, but yes, the state did file down 2 counts of stalking. I can transmit both accusations to Miss Bridgewater so that it can be placed into the record.
Yeah, I know we're having a few problems with the upgrades.
And again, if Miss Fisher is here, we would like the court to sound for her if she would like to speak.
All right, Ms. Fisher, is it Paula Fisher?
Yes, Your Honor. Could you hear me okay?
I have to see you as well.
Okay, let me get back over there. I'm not.
Okay. Oh, okay. All right, that's you with iPhone?
Yes,
Okay. And would you like to address the court today?
yes. Did you want to see me? Can you see me okay?
I can see you. Yeah, I have to see you. Do you want to address the court today or?
Yes, please, Your Honor.
All right, raise your right hand. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
And let me say this, so you can put your hand down. Thank you. This is not your trial. This is a bond hearing. And Deputy Falk, as you heard, has given me the facts of the case. So I don't want a lot of repeating of what she said, but please give me your brief synopsis and what you want to address with the court today. But I'm going to first ask you one question, and that is, are you in fear of Mr. Shringanisha? And I apologize if that's not how you pronounce it. Are you in fear of him?
Very much so, Your Honor. And my daughter is also. I wrote a brief statement and I'll tell you exactly why we are now.
Okay.
So thank you for allowing me to speak directly with you and advocate for my young daughter and myself. It's disappointing to know that Selathuri will be allowed bail. I know he has rights. When my daughter and I have been at the other end of him, completely disrespecting the judge's orders and not adhering to the laws, when he has been told on multiple occasions over the last several years, 2.5 years, to leave us alone. Captains, lieutenants, the judge for the TPO was very clear with him to telling him to stop surveilling us, harassing us, and to leave us alone. And that's what makes us so fearful now. My daughter wanted me to express to you on her behalf. She is also very fearful for her safety. She is a child and she should not have to live in fear constantly. We cannot get away from him. He's our neighbor. We have no family here in Georgia whom we can stay with to get away from this. I'm a single mom. It's just her and I in the home with no one to protect us but the law in your legal system. Your Honor, I understand that the justice system gives these rights to the defendants, the criminals, but the evidence the state has in their possession, I only feel it's fair to ask you to take into consideration that my daughter has rights for her safety also. The protective order was addressed, so I won't go over that. I'm also asking you to please, Your Honor, take into consideration a condition of Selathuri's bond. If you will please have him surrender all his firearms and weapons. Selathuri has bragged to me and other neighbors on multiple occasions of the arsenal he has in his home and how his own door in his bedroom is bulletproof and how he has a safe room in his home where no one will ever be able to get into. And as a mother, that's so scary for me to know this. I also, Your Honor, respectfully ask and believe it's reasonable, Your Honor, for you to consider that the defendant not be allowed to return to the residence. Our driveways butt up to one another. Given the validity of the crime, and now that it's not hearsay, and again, it's been going on since we've lived here, and that he's been surveilling us and stalking my daughter, and she's at arm's length reach away from his residence, that he can go get an apartment while he's awaiting trial. If his wife wants to see him, she can go there. Can you still see me, Your Honor?
I can, yeah.
Okay, sorry. If he can be released to an apartment or stay with a friend, that he can go there. If his wife wants to visit him, she can go visit him there. My daughter has the right to feel safe in her own home, and we have the right to not feel scared like this, especially because he admitted to officers of the law, and it's not hearsay anymore. It's not a witness. It's not he said, she said. He admitted that he willfully wants to scare us. Sadly, I am going to bring this up. He does know how to manipulate the system. That's why it's been going on for so long.
Now, I'm gonna
Yeah.
object to this.
Yeah.
I've been fairly lenient allowing her to go on. I'm gonna object to this time for relevance.
I figured you would, Mr. Githea. I just want to know, Ms. Fisher, would you have been pretty detailed in letting me know the fear and the impact of this matter upon you, and anything beyond that? And you've told me what your wishes are, and the state has presented their recommendations. And so I don't want to go deeper or more specific into any of that. I just need certain factors for me to make sure that you and your daughter will be safe. Do you mind me asking, how old is your daughter?
She's 12 years old, Your Honor.
Well, okay,
And can I just add one more short thing?
okay,
He has shown a pattern that's documented through the police, that he has an uncontrollable sensation to surveil us. He has made good on his threats on everything he said that he wants to do to myself and my minor young daughter. And now those threats are no longer false threats, as they have been documented and said to law enforcement. And law enforcement in the state has the body cam footage of him saying this. And that's all I want to say, Your Honor.
okay. All right, I appreciate your time, and I do understand. Let me go back before Mr. Githea presents on behalf of his client. The state's recommendation was a $10,000 surety bond. Were there any other recommendations or conditions that the state had?
Yes, Your Honor. The state has requested that the defendant stay 200 yards away from Ms. Paula Fisher and the minor child IF, that he have no contact via email, messages, phone calls, third-party contact, social media, and no video surveillance whatsoever. We also requested no alcohol, drugs, or weapons. We will make an additional request that he surrender all firearms to the Fulton County Sheriff's Office.
All right. As far as your recommendation, and I'll let Mr. Githea start there, in recommending the 200 yards away, and their houses seem to be less than 200 yards. How would that play out? How would we be able to do that?
Your Honor, quite frankly, my biggest concern right now is for Ms. Fisher and her safety. Your Honor can structure that however you see fit. However, my concern is mainly that the 200 yards away is necessary to protect Ms. Fisher and her minor child IF. At this point, I believe that this is a present danger to Ms. Fisher. And if this were any other sort of case, we would, be ordering a stay away order from Ms. Fisher and her child.
Okay. All right. Thank you. All right, Mr. Githea.
Thank you, Your Honor. Judge, let's just start at the beginning. One of the few things that was correct from the state is that this is an ongoing neighbor dispute. This has been going on for several years. This is not about anybody being in fear for their safety. This is about the manipulation of the criminal justice system to effectuate a civil matter. There is an ongoing civil dispute where Ms. Fisher is being sued by Mr. Ganesha. And this all started from a property dispute. They literally are feet from each other. I've been able to receive papers and pictures of the disputed property line. Ms. Fisher it all started when Ms. Fisher decided to cut down some trees. There was a dispute as to where the property line was for those trees. Mr. Ganesh then called the authorities, including the local police in Johns Creek, to prevent her from doing so. She had some documentation indicating where she believed the property line to be. The police said this is a civil matter. They did not get involved. They stood by and allowed her to cut down the trees. And that started this war between neighbors, Judge. What was going on is that he would try to get footage of her crossing over the property line, and just different behavior. This was not for purposes of surveillance. This was not for purposes of harassment. A TPO was filed by Ms. Fisher. It was heard by a judge. It was dismissed. The judge did indicate to both parties that he wanted them both, because Ms. Fisher was also recording on their end as well, to both stop harassing each other and to both stop recording. That being said, on this particular incident date, from what I understand, Ms. Fisher might have been doing some yard work. There might have been some laborers for her. I'm not sure if it was her. Some debris was put on their property line. And so he recorded to get evidence for the civil suit. She then calls the police. Police have been out to that location numerous times, Judge, called by not only Ms. Fisher, but by Mr. Ganesh for various reasons. Again, and the police got upset with Mr. Ganesh because he did not get the outcome that he wished to get. And so he escalated it up the ladder to the chief of police. I have a letter in front of me to Chief Rich Austin, which is the City of Milton chief of police. And in it, Mr. Ganesh he indicates that he's not happy. He also indicates that he was not very pleased with their response when they came to his property and that they allowed Ms. Fisher to cut down the trees. This is the reason why he was arrested for stalking charges. Now, when the police arrived, based on my understanding, Mr. Ganesh did indicate that, yes, I was recording her, but I was collecting evidence. And again, Judge, these are, it's blurred out, but these are the pictures basically on the property line. He indicated that he was gaining evidence for that. So it's a shock to me to hear now that the allegations are that he was recording into their home. That was not the case. It sounds like it's being sensationalized, and therefore Mr. Ganesh now finds himself in custody. Judge, this is a person that's never been arrested in his life. I understand the state's trying to taint his reputation or his character by indicating that he's only been here for 5 years. It doesn't matter how many years he's been in this country, Judge, he's a citizen. And he has been in this country. He's actually lived in Milton, Georgia for over 10 years. He's an educated man. He has a background in electronic engineering as well as computer engineering. He has a bachelor's degree in engineering from Canada before, again, moving to Georgia over 10 years ago. He is the founder of Georgia Innovation Labs, where he does contracting. He's now missing out on work as he is solely dependent on his ability to work himself in order to provide for his family. Previously worked at Oracle as head of Innovation Labs, formed his own business last August. Your Honor, he too is the father of 2 children, ages 11 and 12. I have his wife, Ms. Sangeetha, on the line as well, Judge. She can testify in regards to the bond conditions. I won't go into too many of the facts, but I will just say this on the record that she herself indicates that she is feeling in danger because she came out this morning and Ms. Fisher was standing in the driveway laughing at the children and speaking loudly about how Ganesh is in jail. And so she called me and was wondering what she could do to do that. I told her to avoid Ms. Fisher like the plague. Should Your Honor grant Mr. Ganesh what I'm asking for, I'm going to advocate the same to her. Please avoid Ms. Fisher by all costs. Judge, she wants him to not be able to return to his home. And for stalking, it has to be purposes of harassing or intimidating. That's not the case here. I understand we're not here for the merits of the case. I understand that this is something that'll be litigated later. However, the state went into great detail in resuscitating the facts as they believe them to be. So I just want to put that on the record so Your Honor can have an idea that this is not as one-sided as it appears. That being said, Judge, I would be asking for unsecured judicial release. I'd ask that you follow the Ayala factors, which should be the only things for, I shouldn't have to tell or remind Your Honor. So please forgive me. I don't mean to insult you. But I would argue, Your Honor, he's not a flight risk. All of his ties are here. His wife is here. His 2 children are here. I would argue there's no threat of intimidating any witnesses. The alleged facts in this case, as the state has indicated, is that he was taking pictures from his home, possibly into their home. So I would argue there's no threat of intimidating any witnesses. He will gladly adhere to any stay away orders from Ms. Fisher, Judge. And I'd ask you, he's not a flight risk and there's no likelihood for him to reoffend. I would just be asking, Judge, I anticipate this case being litigated. If it has to go to trial, I'm prepared to do so. But I believe that this is a farce and I believe it's a manipulation of the system, Judge. And I would just ask for unsecured judicial release based on the Ayala factors. If you did want to hear from his wife regarding what she would do to comply and make sure he complies with bond conditions, I would just have her testify briefly on it.
No, I don't want to hear from his wife. They are adults and I'm sure would adhere to the court's orders on bond. And this is interesting, but I do hear remnants of being a little more civil than criminal, just in my general opinion. I do understand Ms. Fisher's concerns for the safety of her and her child. And I do understand that this is somewhat bizarre behavior, in my opinion. But we do want to make sure that she's able to enjoy her home. And obviously he has a right to enjoy his home. And the homes seem to be very close. And I believe, if you would agree with me on both sides, that the homes are closer than 200 yards. Is that correct?
That is
Yes.
correct, Your Honor. And Your Honor, I would like to point out this crossed into from any kind of maybe allegation of a civil dispute into a criminal matter when the defendant admitted to police on body cam that his intention was to scare her. That falls squarely into the harassing and intimidating part of stalking. Additionally, the officers took pictures. I understand that Mr. Githia, now that he cannot just attack Ms. Fisher, is now attacking also the entire.
Well, I don't have discovery. I'm not privy
For
to
this.
that.
This is in the warrant, Mr. Githia. So I understand that he, is now attacking the police department now for what they observed. But the reality is there is a camera pointed directly at her house that the defendant placed there, and he admitted to doing so to scare her. That's stalking. I mean, it meets the elements in the criteria of stalking. So it was this defendant's decision to take it that far. And at this point, it is now a criminal matter.
Well, again, this is his first arrest. He has no criminal history. His wife is here. He has 2 children. He has a job. Obviously, he's working and trying to provide for his family. If I were to, again, order, which it is in our bond orders, those 200 yards, I guess he would have to stay on the other side of his home. But I do have slight concerns of the stay away, which is the state didn't ask particularly for a full stay away, leaving it in my discretion. 200 yards, football field.
2 football fields, Judge.
Two football fields. I don't know if that would, be reasonable under the circumstances. Because he still has a right to work, make a living, and take care of his family. And hopefully not to the fault of, anyone else's rights to be free in their home and safe in their home. The civil suit is already filed, correct?
That is correct and pending, Your Honor.
And pending. Okay.
And Ms. Fisher is filing a TPO, Your Honor, based on the actions undertaken by this defendant in the last 2 days.
Okay, the last 2 days. And that may solve it as well. Ms. Fisher, I do see your hand up, and I'm trying to get onto my other cases on the calendar because this is a mix between some civil and criminal. There is certainly both sides of the fence, and I have heard from you extensively. Is it something that will take a half a second that you just want to say? I'm going to lean just a little bit, but I'm not going to hear a dissertation.
Yes, thank you, Your Honor. This is not a civil issue. This has been going on for 2.5 years. The solicitor's office can pull on the 911 calls. They wanted to bring the trees in. They always do. I cut the trees down in March, 5 months ago, because he was in the tree line taking video of my daughter. Now that's 5 months. 5 months ago that was done. This has been going on 2.5 years, Your Honor.
I understand, but it's not been going on as a criminal matter for 2.5 years. Is that correct?
That is correct, because the police reports, it turns into he said, she said, and the lieutenant and the captain said that the best evidence at this point would be to get the police to witness it, and then they could not turn it onto a civil issues. But if they want to talk about the trees, and I'm advocating for my daughter, if they want to talk about the trees, that the trees were taken out 5 months ago. 5 months ago, they filed a suit to turn it into a civil issue. He knows how to ride the law. This has been going on for 2.5 years. There's so many police reports before the trees were taken out. This is definitely not a civil issue. He was told multiple times not to surveillance us, not to harass us, not to record my daughter. The state has much evidence that from Milton Police Department that he has viewed inside the back of the home as extensively as 2 years ago. This is very upsetting how this gets turned around. They did this with the TPO, and I'm going to tell you, I was honest, Your Honor. The judge asked me.
Judge, I'm going to object to testifying regarding what happened in another matter.
Please let me finish.
Specifically regarding the TPO. I'd object at this time, Your Honor, to relevance as well. It's the arguments are being a bit repetitive.
I agree. Ms. Fisher, I do think I have a good understanding from both sides what we have here. And I was just asking, you just had a little bit to say, but I do not want to be repetitive. And again, you will have your day in court at some point, and maybe multiple courts. But I think I have heard enough, and I'm ready to rule. And I don't mean to cut you off to be rude, but you know, I think that again, we could probably go back and forth on this all day. But I am not here to weigh those factors that go beyond this defendant and the Ayala factors of that Mr. Githia has also stated as well. And so I've got to move on. Everybody wants me to move on. So I need to rule on this pretty quickly and move on, okay? All right, I'm going to order a $10,000 signature bond. And with that $10,000 signature bond, I'm going to order that be through pretrial per judge. And I'm going to order, first of all, and that's $5,000 on each, Ms. Bridgewater, each of the 2 stalking charges. I'm going to order that the defendant surrender any and all guns to the sheriff's departments or weapons that he has in his home, because obviously the first condition would be no drugs, no alcohol, no weapons, no guns while on bond. And if he owns them, and not to say give them to your wife. I don't want your wife to have them. I don't want them to be in your home, so that you will not have any access to them. You can turn them over to the sheriff's department once you get off bond, come off bond, if the case is over, they can be returned to you at that time. I'm going to order no further contact with Paula Fisher and no further contact with IF, the minor child. I'm going to order no video surveillance, no cell phone surveillance, no cameras pointed at the property. Property lines are facing the home of the victim. So if you have a phone or anything of that nature, who's raising his hand?
Oh, I'm sorry, Your Honor, I didn't introduce. This is Mr. Peak. He is the attorney that's handling the civil case.
Oh, okay. I really don't want to hear anymore. I've gone on way too long. The jail's going to get me and put me there next if I continue on, because these are issues I really don't want to hear from another attorney to give me any of the civil issues.
I'm only going to ask a question in instruction as it relates to the civil case. Obviously, during discovery, there will be a need for a deposition of Ms. Fisher.
Mhm.
Is it the ruling of this court that Mr. Ganesh cannot appear as a party in that case?
He can appear as a party, but he may not be able to attend her deposition because he's going to have to stay 200 yards away from her and somehow in his home. And I'm toying with the idea of whether he needs to go back or not. But I do, that can be extreme at times, but a lot of defendants, I order them not to go back to their homes. And I'm trying to hopefully help them put a stop to the back and forth of the actions on both sides. But if I order the 200 yards, he's going to have to, without saying he can't go back to his home, he's got to stay 200 yards away from her, which is 2 football fields. So however that needs to happen, or, stay in his house. And if he goes out and sees her, he needs to run back in. I don't know. Short of me saying that he's got to stay away totally from his home. She shouldn't be seeing him anymore.
And I apologize. I'm gonna no more questions except with the deposition, because we do have one that we're going to notice. Would it be permissible for him to participate via Zoom?
He can participate by Zoom.
Great. Thank you, Your Honor.
Your Honor, I just want to make it clear, the no further contact means he is not to have any kind of communication with her.
Right.
So I would advise his attorney to make sure he does not try to speak to her directly with a context of any sort of deposition.
Right. Ms. Bridgewater, just put if in the civil litigation, there needs to be participation by the defendant, that it be by Zoom, but he cannot speak or have any input or knowledge or contact indirectly or directly. And that's what this bond order is going to say with the victim. So he has an attorney. So that attorney should be speaking for him. He can watch on Zoom. That's about the only time he would see her. Otherwise, I'd almost say he can't even have a cell phone, but we'll allow him to have one, but it better not be on a stand facing her property. That would be a direct violation. And if that is found or caught, or you have a picture, Ms. Fisher, of a cell phone in a window facing your property, I hope you can zoom in, get a picture and call the police, and then his bond can be revoked. But he is not to even take any more pictures. I don't also want, and I'm going to add his wife to it, because I feel like there's a possibility if he can't do it, it'll get his wife to do it. I don't want this case to blossom or go to something else. So that should be no one in this house next door, in this family, videotaping, not even their children for that matter, or taking pictures or anything of that sort. This all needs to stop. No pictures by the wife, by the children, by the defendant. There should be no cell phones or cameras facing her property. All right, I'm making that very clear. And I know that's a lot and a mouthful, Ms. Bridgewater.
Yes, it is, but I got it.
Got it. Good. Thank you. And I think that is all. Anything else from either party? I think
No, Your Honor.
Nothing further from this.
Covered everything.
Nothing further.
Thank you.
We would like to, however, make on the record that we object to a signature bond.
Okay, thank you. And I apologize, courtroom 2.
All right, position number 2, Ms. Brown.
Okay.
Thank you, Your Honor. May we be excused at this time?
Yes, you may. Thank you so much.
Thank you, Your Honor.
Thank you, Ms. Fisher. 23 CR 005131A, Chantel Brown, charged with 1 count of simple assault, family violence, pretrial.
First arrest.
Thank you. State.
Your Honor, in this matter, officers responded to a domestic dispute. The defendant and the victim had been in a verbal altercation. At some point, the defendant grabbed the victim's child and began throwing kitchen items at the victim. The victim was able to record the incident and showed the same to the officers. We were able to contact the victim in this case. He had confirmed the events in the warrant and stated that he does want contact, but we are concerned about the risk of reoffense just because of the nature of the offense. Your Honor, we're asking for a $3,000 signature bond through pretrial services. No further contact with the victim in this case, Mr. Jonathan Voltaire, and a stay away from the incident location, which is 220 Peters Street, Southwest Atlanta. It's my understanding Mr. Voltaire will be on Zoom, and so I'd like Your Honor to sound for him when it's at your pleasure.
All right. Mr. Is it Voltaire?
Yes, Your Honor.
Is he on Zoom?
I don't have much to say.
All right. Thank you. All right. Go ahead. And is it PD Abden?
Yes, it is. Thank you, Your
Okay.
Honor. So Miss Brown, she's 23 years old. She was born in Georgia and she's lived here her whole life. She has family in the state. She's a mother to her 2-year-old daughter who she shares with the complaining witness. She denies these allegations and we're not opposed to no further contact. She does have another place to reside with her child. And if Your Honor decides that there would be no further contact, we would just ask for a one-time police escort for her to collect her items because she had been living there. And we would ask for a signature on bond.
All right. I'm going to order that $3,000 signature bond through pretrial. I'm going to order the 1-day anger awareness course. I'm going to order a stay away from 220 Peters Street Southwest in Atlanta. No further contact with the victim. And a one-time law enforcement escort to retrieve any personal items. Oh, and no drugs, alcohol, weapons, or guns while on bond. I think that's it.
Trial position number 3. Ms. Brown.
Thank you. This is 23 CR 005129B. Crystal Brown, is it Stevenson? Charged with 1 count of terroristic threats and acts. Pretrial.
I'm showing 7 cycles, 2 out of Georgia, 5 out of Florida. Last arrest, March of 2016.
They have a
for
bad
disorderly
connection. Didn't
conduct.
get that.
None of it.
I heard 7 cycles and then your connection is not good.
5 out of Florida, 2 out of Georgia. Last arrest, 2016 for disorderly conduct. That was a conviction. A grand theft motor vehicle conviction, 1995 out of Florida. And then a forgery, 1996 out of Florida. Nothing further. Can you hear me?
I can.
Okay, yeah, nothing further.
All right, stay.
Your Honor, in this matter, the officer was working an extra job at the incident location, which is the Believe Music Hall. The defendant was asked to leave the location and got into a verbal altercation with our victim, stated she would retrieve, the defendant stated that she would retrieve her firearm from her car and shoot him. We attempted contact with the victim. We were not able to reach him. In light of the limited history, Your Honor, we'd ask for a $3,000 signature bond through pretrial services, the 1-day anger awareness course, no further contact with the victim, Mr. Emmanuel and Anekak. I'm going to try this again. Anitnaqua, Your Honor. Stay away from the incident address and no alcohol, drugs, or weapons while out on bond.
All right. PD Abden.
Thank you, Your Honor. Ms. Brown Stevenson, she is 49 years old. She's a proud mother to 2 children. She works as a senior staff accountant at Unified Aviation Services, where she has worked for 18 years. She resides in Georgia, and she's been living here for some time. She strongly denies these allegations. She also does not know the complaining witness. She stated to me that she doesn't know this person. And we would ask for signature on bond, and she has no issue with the stay away from the incident location.
Okay. All right, that'll be a $3,000 signature bond through pretrial. There's a stay away from the incident location. No further contact with the victim. 1-day anger awareness course through pretrial. No drugs, alcohol, weapons, or guns while on bond. And I think that's it. Anything else?
No, Your Honor.
Position number 8, Your Honor, Ms. Hightower.
You said 8.
Yes, ma'am.
Understand, do we need a breakout still on 8?
Yes, please. I would ask for a breakout session, Your Honor, for this.
You want to
client.
hold this one? Is it this one and 13? 8 and 13 need a breakout?
That's my understanding, Your Honor.
You want to hold those to the end, or?
Yeah, that works.
I think
Well,
that's
I'm
typically
asking
easier.
the jail. I usually defer to my deputy sometimes.
If she can use the phone, get on the phone and cook, yes. But if she has to do a breakout on here, we'll wait till the end. So she can either call and talk, have a conversation with both of them, or we can just keep going and put to the end. It's up to you.
Which would you all like to do? I think one is PD Abden and one is PD Kim.
Yes, Your Honor.
We both can call the numbers. The same one that Ms. Advan called, she can call that one. The same one Ms. Kim called, she can call that one. They can have a conversation at the same time. That way we knock 3 birds out with 1 stone. Get things
Right.
done. Or if you want to talk to them face to face, then we'll have to do it again. So we spent like 30 minutes on one case.
I know.
So we
I
try to-
Apologize.
That's okay.
I-
We just gotta get this thing
I
rolling.
do. The problem is if we have the 2 of them, do we have anyone else on for the cases, or all the cases belong to the 2 of you?
Or we just do it one at a time. And Ms. Kim can give me her cases and I can pull her people, or Ms. Kim can go first and I can pull Ms. Abdan's people.
Okay,
I'll do it. I just want to be productive.
keep it moving.
Yes, ma'am.
I understand, Deputy.
Sorry, Your Honor. So also for Ms. Chantel Brown, I forgot to ask for this, for a third-party transfer for child visitation, so she can parent her child, if that's okay.
Yes, we'll add that.
All right, thank you.
To Ms. Brown.
And for position 8, I would need a breakout session with the court, or for it to be off of Zoom when we're all done, not with the client herself.
Okay.
Yes, Your Honor, I was under the impression that the breakout room was for like possibly MH issues, not to talk to the client as themselves.
Is that true,
Is that
Ms.
correct?
Abden?
My first day.
Oh, so you do need to interview this?
No, I do not. I would need to
No.
speak
Oh.
with the court. We can leave it till
Okay.
then if you'd like. Thank you.
Okay, thank you, Ms. Champion, for helping us out there. And PD Kim, yours is just a breakout, but you've already spoken and interviewed the,
Yes.
okay, thank you, Deputy. They have both interviewed them. We'll just hold to the end because of the other concerns.
Thank you.
Okay,
So
thank
do
you.
we need to hold both of the individuals to the end?
Yes, they're both shaking their heads, yes. Because it looks like you have a courtroom full. And so with those issues, they would like to hold them to the end.
All right, position number 1, Ms. Barnes.
Okay, This is 23 CR 005130H. Jaquavius Barnes, charged with 1 count of battery family violence, 2nd count of obstructing or hindering person making emergency phone call. Pretrial.
5 cycles. Last arrest, May of 2022 for theft by receiving stolen property. That was out of the city of South Fulton, but there was no case in the Odyssey.
Okay.
A DUI conviction from 2018, and then a first offender for aggravated assault, family violence, battery family violence, and cruelty in the third in 2019. I'm not sure if that was sealed, and nothing further.
Okay. State.
Your Honor, in this matter, officers responded to a domestic call. The defendant fled the location on foot, but was quickly located and brought back to the location. The victim stated the defendant punched her in the face, wrestled with her, and snatched her phone away when she attempted to call 911. And officers were able to observe swelling to the victim's right eye. The incident location is the victim's address. The victim was arrested, but has been determined to not be the primary aggressor in this matter. Your Honor, we had some trouble, or I guess some disagreement in calculating. It's our office's belief that he is still on probation on the 2019 conviction. So we're asking for a $7,500 surety bond. That'd be $6,000 on the battery family violence count and $1,500 on the hindering 911 call count. We'd also ask for no further contact with the victim, Ms. Michelle Todd, and to stay away from the incident location, which is 245 Basswood Court, South Fulton.
Okay. And Ms. Apple, PD Apple.
Thank you, Your Honor. And just to confirm, you know that he's still on probation, or you're still unsure?
So in candor to the court, my calculation, I believe that his probation ran out last year. When Deputy Falk reviewed it, she believes that she's still on probation, and she has a lot more experience with the documents than I do.
Okay.
Let me just interject, since my name was brought into this. He was on probation. I'm not sure if he is still on probation. I was just pointing out, as a part of the order, he was given probation.
Gotcha.
Okay.
Thank you.
Then no, I don't believe he is on probation. No.
Okay.
Thank you. Thank you. All right. So Mr. Barnes is 33 years old. He is a father to 2 boys. They're 13 and 2 years old. He was born in Georgia. He's been living here his whole life. He works a temporary job as a forklift operator. Since he is not on probation, we would be asking for signature on bond or a surety bond less than $1,000, as he cannot afford anything else, and anything more would be like giving him no bond. And he and the complaining witness do not have any prior incidences despite his criminal history. And he also is okay with no contact, and he has somewhere else to go if the court is inclined to order no contact. Thank you.
Okay. All right. I'm going to order the $7,500 surety bond, $6,000 on the battery, $1,500 on the obstructing or hindering of the 911 call. I'm going to order a stay away from the incident location, no further contact with the victim, Michelle Todd, no drugs, alcohol, or weapons or guns while on bond. And if there, I guess if there's visitation or anything that would be done by a third party, I understand. Are these the 2 children between them or no?
I don't believe that's relevant in this case.
Oh,
Your Honor.
no.
I did not see
Okay.
that.
Yeah, I believe I believe he said that they're like his children. It's Miss Todd's children.
Okay.
Who is his girlfriend.
Okay, so no, I will not order that then. We'll stop where I was.
Thank you.
Anything else, counsel?
Nothing further, Your Honor.
Okay.
Position number 4, Your Honor, Ms. Canty.
Okay. 23 CR 005128G, charged with 1 count of criminal trespass, pretrial.
I didn't hear the deputy at the jail. What was the position number?
4 Cordell Canty.
Yes, Judge. He has 29 cycles. Last arrest was out of DeKalb County from April of this year for possession of a Schedule II controlled substance and possession
I can
of
barely hear
deadly
you.
object.
I can barely hear you. And again, I think your connection is just not good. It's in and out. I heard 29 cycles and something with the cab.
Give me 1 second. I'm gonna try to switch the Wi-Fi. I'll do it after this case. Can you hear me a little bit better?
It's very fuzzy. Is anyone else having trouble hearing it? Yes, okay. I think ASG Ferguson, I don't know, PD Kim, and we're all having trouble hearing it. Very fuzzy. Sounds like you're kind of in a hole somewhere. Try it again, maybe.
Can you hear me
Nope.
better?
It's a little better.
Okay, after this case, I'm gonna switch locations to get better
Okay.
internet connection.
Okay.
29 cycles, last arrest, April of 2023 out of DeKalb County for possession of a Schedule II controlled substance and possession use of drug-related object. There was no disposition on that case.
There's
One
no what?
FTA from
Say that
2021.
again. There's no, you said there's no something.
Disposition for the.
Oh, disposition. Okay.
Yes. 2021 FTA. A robbery conviction 2015, Florida. A larceny conviction 2013, Florida. Possession of cocaine conviction 2011 out of Florida. A grand theft conviction 2009 out of Florida. A burglary conviction 2009 and 2011 out of Florida. And nothing further.
All right. Thank you. State.
Good afternoon, Your Honor.
Good afternoon.
On August 21st, 2023, at approximately 2:43 a.m., an officer was called to the racetrack located at 1545 Mansell Road, where the officer observed the defendant on this property. The defendant was issued a criminal trespass warning for the same property in July of this year, so he did knowingly and intentionally remain on the property after adequate notice to stay away. As Your Honor has heard from pretrial, there are about 20 arrest cycles out of Florida and about another 9 out of Georgia. There are also 2 previous convictions from Fulton County. One has a notation of failure to successfully complete probation. There's also currently an open case in Fulton County that has issued a bench warrant. That is case number 21CR003274G. And we are asking that that case be added to the SAP calendar along with this current case. The state is recommending a $1,000 surety bond, which is reduced from the bond set by the judge, no alcohol, drugs, or weapons, and a stay away from the racetrack at 1545 Mansell Road. Thank you, Your Honor.
All right.
Yes, Your Honor.
PD Kim.
My client is 35 years old and he was born in Florida, but he moved to Georgia about 26 years ago. So this is his hometown. Your Honor, he has a solid address where he resides with his girlfriend, and he has his brother here in Georgia. Your Honor, he recently lost his mother and he has not been able to work for the last couple months. So he's qualified for public defender services. He's going through a financial crisis, and we would like to request for a signature on bond since he has no financial means to pay for bond. He graduated from high school, and Your Honor, we would like to request for a signature on bond. Thanks.
Okay. I'm going to give me the state's recommendation again.
Yes, Your Honor. Our recommendation is a $1,000 surety bond that's been reduced from the bond originally set by the judge. No alcohol, drugs, or weapons, and a stay away from racetrack at 1545 Mansell Road.
All right. I will order that $1,000 surety bond, stay away from the racetrack or the incident location. No drugs, alcohol, weapons, or guns while on bond. And I guess that'll be it.
Thank
Anything
you,
else?
Judge.
Yeah, thank you.
Thank you.
Yeah, I apologize. That was a $1,000 surety bond, correct?
Correct.
So okay, position number 5, Your Honor.
Okay, no problem. This is 23 CR 005132G. Sharif Durosinmi or Durosinmi. Charge of 1 count of battery, family violence, 2nd count of cruelty to children. Pre-trial.
Pretrial is coming back into the Zoom, Your Honor.
Right. I was going to say, I think she was switching.
Your Honor, I'm happy to volunteer. This is defendant's first arrest.
Okay, Judge, I'm back.
Okay. All right. We're on position 5. Durosinmi. Sharif.
First arrest.
Okay. All right. No wonder you volunteered for that, Mr.
Yeah, it's an easy one. Yeah,
It's
I'm
an
not
easy
volunteering
one.
for the big ones.
Yeah, that's an easy one. Good.
Yeah.
All right, go ahead.
Your Honor, in this matter, officers responded to a damaged property call. And defendant stated to officers that the victim, who is the defendant's child's mother, damaged his TV and 2 computers. When victim met with officers, she showed the officers a recording of the defendant's other child's mother damaging the same goods. She also showed a recording of a physical altercation between the defendant and the victim that was recorded by the victim's minor child. Officers observed swelling and bruising to the victim's face, neck, and arms that was consistent with the injuries sustained from the recorded altercation. So, Your Honor, we are asking for a $5,000 surety bond. That would be $4,000 on the battery count, $1,000 on the cruelty count, no further contact with victim Sofiette Rashid or her child TR, and stay away from the incident location, which is 5742 Village Loop, South Fulton.
That's his home. He can't stay away from there.
Excuse me? Who's talking? Who doesn't have permission to talk?
I don't know who that was, but Your Honor, they stated that it is the address, that is his home, and the complaining witness does not reside there.
All right, go ahead and present. And if you're not called upon to speak and you're a witness, please do not speak out of turn and speak out in my court. Thank you.
Your Honor, my client is 40 years old. He moved to Georgia in 2016. He went to college, got an economics degree in Nigeria, and he recently had open heart surgery, which has prevented him from attaining gainful employment. And he's not yet secured any SSI for his disability. He firmly denies these allegations and said that she caused him, the complaining witness caused him severe injuries. Specifically, she bit him, he claims, he told me that she was the first aggressor in this incident, and she does not reside at this location, like I said earlier. So we would object to a stay away, as this is where he resides. And given his financial circumstances and the situation, we'd also ask for a signature on bond.
Your Honor, I'd like to request that the warrant doesn't state that the victim does not live there. So I don't have any basis to believe that she does not live there. I'd like to at least ask, if not a stay away, then a law enforcement escort to confirm that she is not staying there.
All right.
I'd also like to sound for Ms. Sophia Rashid.
Right. Miss Sophia Rashid, is it Rashid?
Rashid, yes, ma'am, the last name.
Okay. Miss Rashid. Don't think she's on the Zoom. But what I'll do, I'm going to order a $5,000 signature bond, and that signature bond will be through the jail. I'm going to order that $4,000 on the battery and $1,000 on the cruelty. I'm going to order no further contact with the victim, Ms. Sophia Rashid. As far as the stay away, when the defendant is released, he needs to arrange a law enforcement escort to return to that property. And once they return there, if it is determined and the officer sleeps that property that the victim does not still reside there, then you can reside there, Mr. Durasimi. If she has items there and it looks like she's still there, then you'll have to find somewhere else to stay until it can be properly determined that the victim does not reside there, okay? No drugs, alcohol, weapons, or guns while on bond. And that should do it.
Position number 6, Mr. Dykes.
Okay. This is 23 CR 005134E, Christopher Dykes, charged with 1 count of hit and run, 2nd count of failure to obey traffic signs, signals, and markings. Pre-trial.
Has 12 cycles. Last arrest was August of 2016 for a probation violation.
We didn't get that.
Florida. 12 cycles. 12 cycles. Last arrest was from August of 2016 for a probation violation. He has a robbery conviction in 2005, a hit and run conviction in 2005, and a fleeing or eluding law enforcement officer conviction in 2005. And nothing further.
All right, I know that you may have switched to something. I'm beginning to wonder if it's better than what we had before. We went out on this again and came back. It's still pretty shoddy. But we'll keep trying to go. If not, the state will have to give me the histories. All right, go ahead, state. I'm sorry, ASG Ferguson.
That's okay. Thank you, Your Honor. On August 19th, 2023, an officer observed a green Corolla, Georgia license plate CDE 2615, stopped in the intersection of Holcomb Bridge Road and Roswell Road. Simultaneously, the officer witnessed a silver sedan back away from the Corolla on Old Roswell, then leaving towards Highway 9. The driver of the Corolla, Awad Otham, spoke with the officer and advised a male with a dark complexion was driving. The officer reviewed traffic cams, which showed a 2018 silver Honda Elantra with a Georgia license plate of CTN 3902, registered to 369 Carriage Place in Alpharetta. The officer went to the location and observed damage consistent with the accident. Upon speaking with the defendant at the address, the defendant advised that the vehicle was not his and he had nothing to do with the car. However, the officer also observed signs of the defendant being under the influence of marijuana, and he advised the defendant that the vehicle would need to be impounded for processing. On August 20th, the car's owner, Monica Cowan, came to the police station to provide proof that she was not the driver of the vehicle on August 19th. Ms. Cowan also stated that the only person she allowed to have access to the car was the defendant. Based on the foregoing and the fact that the owner of the car had an alibi for the evening, as well as the officer located personal items of the defendant in the car, the officer concluded that the defendant was guilty of, or had reasonable suspicion to believe he was guilty of driving hit and run, duty of a driver to stop at fault, and failure to obey signs or control devices, which we have accused today. Our recommendation for bond is a $1,500 surety, $1,000 on count 1 for the hit and run, $500 on count 2 for the failure to obey. No alcohol, drugs, or weapons. No further contact with Awad Otham, and no driving unless for work, medical reasons, or to attend court. And at this time, I would like to sound for Awad Otham, the other driver.
All right. Is anyone else here on this case? All right. Go ahead, PD Kim.
Yes, Your Honor, my client, Mr. Dykes, is 37 years old. And Your Honor, he was born in Florida and he moved to Georgia about a year ago to work at Computer Center full-time. He graduated from high school, and Your Honor, he has a 4-year-old daughter who has a very special needs that he has to take care of. It costs a lot of medical bills. And we would like to request for a signature on bond for these driving incidents. And Your Honor, that's about it, Your Honor. Fortunately, all those charges were from kind of remote years. So I think he should get another chance to have a signature on bond. Thanks.
Mm-hmm. I'm going to order the $1,500 signature bond through the jail. I'm going to order no drugs, alcohol, weapons, or guns while on bond. I'm going to order no driving except for number 1, if he has a valid driver's license, to even drive for medical assistance, for work, or to see his attorney, or to come to court. Otherwise, he should be at home. And I believe that is it.
Excuse me, Judge. Oh, I'm sorry. Excuse me, Judge. We did ask for no further contact with Awad Otham, the other driver.
Oh, and no further contact.
Thank
with
you,
the
Judge.
other driver, yes.
Number
Go ahead,
7.
Ms. Bridgewater.
Will you break that bond down, please?
Oh, 1,000 on the hit and run and 500 on the failure to obey.
Thank you.
Mm-hmm.
Thank you.
Thank you.
Position number 7, Mr. Gillum.
23 CR 005133C, charge of 1 count of battery family violence, pretrial.
18 cycles. Last arrest, 2004, DeKalb County, for armed robbery and possession of a firearm by a convicted felon. That was a conviction. A 2002 conviction for driving while license suspended or revoked. A 2001 conviction for 4 counts of reproduction of recorded material. 2001 conviction for forgery. Armed robbery conviction in 1989.
Won't go back that far.
All right, well, nothing further.
Okay, thank you.
You're welcome.
Your Honor, I would just highlight from that maybe the reason for the age of some of the history of the 2004 conviction carried a sentence of a confinement 12 years. Your Honor, in this matter, officer responded to an injured person call. When the officer arrived, they met with the victim, who is the defendant's wife, who stated she'd been in an altercation with the defendant. She stated that she and the defendant had been in a verbal altercation, and the defendant struck her in the face multiple times and then left the residence. Your Honor, in this case, the victim's left eye was swollen shut to the point that she could not see out of it for 1 week, and she sustained other bruising and swelling to her face. We made contact with the victim. She stated that they continue to live together. She confirmed the events in the warrant. She stated that she would like to have contact and will be on Zoom, but Your Honor, we are concerned about the severity of the injury and the risk of reoffense. We're asking for a $4,000 cash bond. No further contact with the victim, who is Miss Miranda Gillum. A stay away from the incident address, 2565 Bonnybrook Drive Southwest. No alcohol, drugs, or weapons. I would like to sound from Miss Gillum.
All right, Ms. Gillum. Ms. Gillum. Nope. All right, go ahead, PD Apton.
Thank you, Your Honor. My client is 61 years old. He was born in Georgia. He has 3 daughters, twins who are 6 years old, and his oldest is 11 years old. He works at Old Lady Gang, a restaurant, and he stated that his wife wants him back. She's not afraid of him. Of course, she's not on the call today. This is the first.
I am here. I am here.
All right, hold on a second. If you're going to address the court, I would need to see you.
Your Honor, would you like me to continue or speak with?
Let's see real quick. Hold on a second.
I'm trying to get the video, but to do it.
I can see it. You're just not in front of it, it appears. I can see the side of your shadow. Looks like your camera's on. Just hold there, Miss Miranda, Miss Gilliam. Go ahead and finish, Abden.
Thank you, Your Honor. So it is my understanding from my client that his wife would like him to return and that she's not afraid of him. And she's here. She can confirm that, I hope. And he is the breadwinner in the family. The family pays a mortgage and that. So I do ask that he gets released on signature bond.
All right. Miss Gilliam, if you can't figure out your camera in the essence of time, just go ahead and mute yourself and I will give my ruling.
I'm here.
I cannot wait for you.
I understand.
Right. But I would need to see you and swear you in.
I'm trying. I don't know how to do it.
Okay. Have you talked to anyone from the solicitor's office?
Give me 1 second. Maybe I have to leave and come back.
I won't have that kind of time today. Have you talked to anyone from the solicitor's office already?
Your Honor, we did make contact, and I can read more extensively
Okay.
the notes that our victim advocate took if you would like.
Yes, let me just have those. And Ms.
Yes, Your Honor.
Champion, make sure you mute her for me. Thank you.
The victim and defendant are married. They live together at the incident location. Victim confirmed the events in the warrant. Victim confirmed her injuries. Victim stated that she was unable to see out of one of her eyes for about a week. She also stated that she did seek medical attention and was given pain medication. She stated the defendant nursed her back to health. Victim stated that they were both drinking at the time of the incident. She stated she's not in fear of the defendant and wants contact. Victim stated that they have been living together since this incident and there has been no violence since. She stated that this has never happened before.
Okay.
Hello?
Yes.
Okay, I'm here.
All right. Raise your right hand for me quickly. You affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury.
I do.
All right. My question is, are you in fear of Mr. Gilliam?
Absolutely not.
And I understand that you want him to come back home. Is that correct?
I do.
Okay. And this incident date was July 21st. Is that correct?
Absolutely.
Okay. And so until his arrest, and I don't know how many days he's been in because it's not on my calendar.
Just one day.
Just one day?
Yes, ma'am.
Okay.
But
All right.
he has not been a threat to me at all in our whole 7 years of me and my friend.
Okay. All right. I'm going to go ahead and give my ruling now. You can mute yourself for me, Ms. Gilliam. All right. I'm going to order a $4,000 surety bond. I'm going to order no drugs, alcohol, weapons, or guns while on bond. And I am very concerned about the severity of this incident, even though it looks like it happened over a month ago. And you're stating here today to the court that you want to have contacts. I'm going to order no further violent contact between the two of you. And I guess that's it. No drugs, alcohol, weapons, or guns while on
Ma'am, I do have to say that him and I have been living together since this incident for the past month, and we have not had any issue.
I understand.
We have both stopped drinking, and I do want my husband back home. My
Well, I
kids
did
do
not
as
say,
well.
if you listen to me, I did not say he should stay away. I just said no further violent contact. And he's on a surety bond. I'm not going to give him a signature bond because of his history. So there's a $4,000 surety bond. You go through a bonding company, they'll tell you how much you need to pay, and then he can get out that way. But I'm not going to give him a signature bond because of the history. But I did do a $4,000 surety bond. The state was asking for a $4,000 cash bond, so I did not do that.
Yeah,
Okay.
Y'all in position number 9, Mr. Jackson.
You said 9.
Yes, ma'am.
23 CR 005136A, Ronald Jackson, 1 count of simple battery, family violence, pretrial.
2 cycles. Last arrest, December of 2019 for stalking. That case was dismissed. We had a 2019 forgery arrest out of Bibb County. There is no disposition for that case.
All
Nothing
right.
further.
All right, state.
Yes, Your Honor. In this matter, officers responded to a simple battery call and made contact with the victim, the defendant, and a witness. The victim stated that he and the defendant, who is his brother, were having a verbal argument and the defendant struck him in the face. The witness corroborated the victim's telling of the events, and the defendant stated that no altercation had been happened. Based on that, our officer made an arrest for simple battery charge. Our office did attempt contact with the victim, but was not able to reach him. We're asking for a $2,000 surety bond, no further contact with the victim, Mr. Joseph Johnson, and a stay away from the incident location, which is 611 Camelot Drive in South Fulton. I would like to sound for Mr. Johnson.
Mr. Johnson. Mr. Johnson. All right, doesn't look like he's here. Go ahead, PD Abden.
Thank you, Your Honor. Mr. Jackson's 24 years old. He graduated from high school. He's lived in Georgia his whole life. He's from Macon, Georgia. He's currently employed at a tire shop. I do want to add that the complaining witness it is my client's position that the complaining witness was the first aggressor. And without going too much into the facts, the witness is the complaining witness's girlfriend. Neither one of them are here today, and he does not object to no contact or a stay away from the incident location. But I will ask for a signature on bond.
All right, I'm going to order a $3,000 signature bond through pretrial per judge. I'm going to order no further contact with the victim in this case. And I'm not sure who lives at 611 Camelot. Do we know?
I don't think PD Apton's advocating that her client lives there. So I think a stay away would be a good idea.
It's my understanding that it is his brother's home address.
No, okay. So we'll just say stay away from the incident location.
Thank you, Your Honor.
Thank
No
you.
drugs, alcohol, weapons, or guns while on bond.
He said.
And since it's through pretrial, I'm gonna order the 1-day anger awareness course.
This
Did
number
any-
2, Mr. James. No. Yeah.
Who do we have next?
Position number 10, Mr. James. Yeah, you're muted.
I'm sorry, I didn't know it was muted. 23 CR 0051337E, Nicholas James, charged at 1 count of pointing or aiming a gun or a pistol at another. Pretrial.
10 cycles, last arrest, 2019 out of DeKalb County for battery family violence. That case was dismissed. A 2012 conviction for possession of marijuana less than an ounce. And then a DUI conviction in 2007, and nothing further.
All right, state.
Your Honor, I would just clarify for the court, we filed 2 counts of the same charge. So the calendar
so
should
two
read 2
counts?
counts of pointing handgun.
Can you hold on 1 second?
Yes, Your Honor.
All right, have we solved the discrepancy? Do we have 2 counts filed down?
I can tell you I filed them down, Your Honor, but in light of the technology issues, Be great if someone from
Yeah.
the clerk's office could tell me whether or not I did it right.
Ms. Bridgewater or Ms. Champion? Is there anyone to check with? Do we have 2 counts or 1? What do you have at the jail?
We have one, Your Honor, same, as the, other person.
Okay, you just have 1 count?
Yes, ma'am.
Well, unless something changes by the time we get the orders over to the jail, we'll have to go with the 1 count. See anything?
Your Honor, the
Deputy
state
Fox?
will be sending over both counts to Ms. Bridgewater and to the clerk's office. Again, this is just a disconnect with the Odyssey.
All right, so there's 2 counts of pointing or aiming a gun or pistol.
That's
All right.
correct, Your Honor.
Go ahead, Mr. Pilar.
Your Honor, in this incident was a road rage incident where a defendant pointed a handgun at 2 victims in a threatening manner while merging into heavy traffic. The victims were able to take a picture of both the defendant and the vehicle he was in. The officer found that the vehicle and the license plate came back to a rental company from which the defendant had rented the vehicle during the incident date. And each victim was also able to separately identify the defendant in a photo lineup. Your Honor, and again, relevant to the 2 counts, we're asking for a $20,000 surety bond. That'd be $10,000 per count. No further contact with either victim, Miss Yolanda Adams or Miss Regina Barnes, and that the defendant surrender all firearms to the Fulton County Sheriff's Office. We were not able to contact the victims, but I'd still like to sound from Miss Adams and Miss Barnes.
All right, Ms. Adams and Ms. Barnes. Don't think you have anyone on by those names. All right, go ahead, PD Apton.
Thank you, Your Honor. Mr. James is 37 years old. He was born in Georgia, has lived here his whole life. He has had 2 years of college studying public relations. He is gainfully employed at Amazon as a shipper. He recently proposed to his fiance. They have a 5-year-old daughter together, and she's due for another baby on September 3rd. He is firmly denying these allegations, and he communicated to me that there's been an issue with identity, which, we'll reserve that argument for not for this bond hearing, but I did want to make the court aware of that. So we would ask for a signature on bond and on both, if that's possible, just so we don't have any issues with him getting out or anything like that.
And tell me the state's recommendation again. Oh, it was 10,000 on each. Was that correct?
That's correct, Your Honor.
Okay.
No further
I had it.
contact, surrender all firearms.
Okay. And did you say both of the victims' names?
I did, Your Honor. I'm happy to repeat them if you'd like.
I know we sounded for them. Tell me again.
It's Miss Yolanda Adams.
Oh, okay.
And the second is Miss Regina Barnes.
Okay. All right, I'm going to continue moving forward with us having 2 counts, Ms. Abden. I think they'll get it straightened out.
Thank you.
I'm going to order the $20,000 surety bond, 10,000 on each count. I'm going to order no further contact with the victims, Yolanda Adams and Regina Barnes. I'm going to order, if he has, Mr. James has any other weapons, that he surrender them to the sheriff's department immediately upon his release, whenever that may be. And also while on bond, no drugs, no alcohol, no weapons, or no guns. We shouldn't even have any guns. And I said no further contact with the victims, and I guess that's all I can order at this time. I would say some restrictions on driving, since the allegations are pretty strong as far as what happened, but I know he's innocent till proven guilty, so I won't restricted driving at this point, but certainly having no weapons of any sort, whether it be a gun, knife, or whatever. So no weapons while on bond. Okay, 20,000 surety.
Position number 16 was somehow
16. 23 CR 005145B, Kendrick Summerall, 1 count of criminal trespass. Pre-trial?
4 cycles. Last arrest was from the 15th of this month out of Cobb County for purchase, possession, manufacture, distribution, or sale of marijuana. The case is open. And then he had an arrest from April of this year out of Clayton County for purchase, possession, manufacture, distribution, or sale of marijuana, and possession of a firearm during the commission of a felony. Case is also open, and nothing further to add.
What was the total number of cycles again?
4.
Okay. All right, State.
Thank you, Your Honor. On August 21st, an officer was called to Planet Fitness in reference to the defendant who had previously been issued a notice for trespassing at the Planet Fitness that's located on 10790 Alpharetta Highway in Alpharetta. The officer received reports from staff at Planet Fitness that the defendant was back on site and was threatening and harassing staff members. So he did knowingly and intentionally remain on the property after adequate notice to stay away. The state is recommending that we remain or have the $600 surety bond remain in place as set by the judge. We are asking for no alcohol, drugs, or weapons, and we are asking for a stay away from Planet Fitness at 10790 Alpharetta Highway.
You recommend keep it at the 600 surety.
I'm sorry, Your Honor.
You're recommending to keep it at the 600 surety?
Yes, Judge.
Okay. Yes, I'm sorry, pretrial?
Judge Mincy, the history I just read off was incorrect. There's somebody in felony with the last name Timberland, and I was moving too fast.
Oh, the Summerall.
Yes. He has 2 cycles. Let me get back to his. He has 2 cycles, with his last arrest being from March of 2018. And that arrest was for 2 counts of battery, 2 counts of robbery by sudden snatching, and willful obstruction of a law enforcement officer, and criminal trespass. And according to his GCIC, it appears that everything was dismissed or not prosecuted. I do not see the robberies listed. That case number is 19 CR 002482J. So I'm not sure if the robbery is still open. That was out of Alpharetta. His first arrest was also dismissed. It was a driving without valid license. And nothing further.
Okay. All right. State. Oh, well, you've already presented. I'm sorry, PD Ferguson. Yeah. Go ahead, PD Ken.
Yes. My client is actually 25 years old, no, 24 years old. And he was born in Germany, but he came here 20 years ago, and he is now a US citizen. Your Honor, he resides with his parents, brother, and siblings are all here in Georgia. This is his hometown. No reason to run away, or he's not a flight risk. Your Honor, we would like to request for a signature on bond. This is criminal trespass. That was actually, there was no written warning in the previously, and he is not qualified for public defender services. My representation is only for the purpose of the bond. He graduated from high school and he does have different kind of jobs. That's it, Your Honor. Thank you.
All right. I'm going to order a signature bond through pretrial per judge. I'm going to make that $1,000 signature bond through pretrial. I'm going to order no drugs, alcohol, weapons, or guns while on bond. And I'm going to order a stay away from Planet Fitness at 10790 Alpharetta Highway. And I guess that's it. Was there any persons for no further contact at that location, or just stay away period and that'll cover it?
No, Your Honor, just the stay away period, and that would cover it.
Okay.
I did want to clarify some of the criminal history. We have that there were 4 cases and arrests between February and March of 2018. The charges that listed, we do believe that they were correct, but I did want to add those additional cases that we found in our breach in our GCIT notes investigation.
All right. All right. Thank you, ASG Ferguson. All right. That should conclude it.
Again?
I'm sorry.
I want to let shooting ball again.
I didn't hear that
Shooting
again.
ball.
Signature.
I mean, how much was the signature?
Oh, 1,000 signature bond through pretrial.
Appreciate you.
Okay.
Position number 17, Mr. Position number 17.
I know. I don't like to mess up the names too bad. I agree. 23 CR 005142G. Is it Mr. Umibi Patrick? And I apologize for mispronouncing your last name. 1 count of simple battery, family violence, pretrial. Or
Yes.
state. Oh, go
I
ahead.
have 1 cycle with the arrest being in March of 2019 for possession of marijuana less than an ounce. That case was dismissed.
All right. State.
Yes, Your Honor. This incident happened on August 21st, 2023 at 5516 Sable Way in South Fulton. Clarence Franklin was in a physical altercation with the defendant. The defendant and Mr. Franklin were arguing about the defendant having Mr. Franklin's keys. Mr. Franklin stated when he came back to the residence to retrieve his keys, the defendant seemed hostile. The defendant then asked about his phone, and Mr. Franklin said he didn't know where the phone was at the moment. At that point, Mr. Franklin stated the defendant pushed him against the wall and a physical altercation ensued. Mr. Franklin, according to the officers, was observed to have a busted lip. We will state that we have had an opportunity to speak with Mr. Franklin. He will, I believe he is here on the Zoom, and we would like to sound for him at the conclusion of our recitation of facts. He stated that they have been together for 3 years, have no children, and reside at the 5516 Sable Way address. He also stated they don't have any history and he is not in fear of him. However, and I would like to question him regarding the incident itself, based on the fact that the police were called and did arrive at the location and met with Mr. Franklin in regards to the incident. The state is recommending a $3,000 surety bond. We are asking for no further contact with Mr. Clarence Franklin. Stay away from 5516 Sable Way. No alcohol, drugs, or weapons. 1 day anger awareness. We are aware that Mr. Franklin does wish to have contact with the defendant. However, this incident happened yesterday and there has not been adequate cooling off time for which the state is concerned. That's all for the state. We would like to sound for Mr. Clarence Franklin.
Yes, Mr. Franklin, are you on? Let's see.
Hi,
Clarence
Honor.
Franklin. Oh, okay. Zoom
How are
user.
you?
Yes. Would you like to address the court?
Yes, ma'am. Yes, Patrick.
Hold on a
Galetti.
second. Hold on a second. I have to swear you in. Raise your right hand for me.
Yes, ma'am.
Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right, put your hand down. What would you like to tell me?
So yes, Patrick and I have been dating for 3.5 years. It has been a wonderful relationship, but I've not felt threatened or anything by him. This was a altercation that turned into something way bigger than it should have been. A simple disagreement turned into pushing and shoving of each other. It wasn't like fist punching or anything. And I definitely don't want to press any charges or anything. I want the best for him. I still love my boyfriend. And I hate that we're in this situation. But I would like to, I guess, be around him if I can, but I understand if I can't be. But I would say Patrick has never shown any signs of aggression or anything towards me or my friends or family or anything. He's even a nurse. So that's another worry of mine, is that I don't want anything to impact his career off of this, if that's possible, Your Honor.
Well, this is not
Because
the trial. This is just the bond hearing. But obviously the police
yes, Your Honor.
were called out. So someone called the police, and sometimes we're not at leisure to control that. But when the police are called, then it's a police matter at that point. So are you saying that you do want to have contact with the victim, Mr. Franklin?
Yeah, I would like contact with him if he is okay with that.
Okay. All right, I appreciate the information. Let me, yes, Deputy Falk.
I just have one question for Mr. Franklin, Your Honor.
Mhm.
Mr. Franklin, are you the person that called the police?
No, ma'am, I'm not.
Do you know who did call the police?
Your Honor, it was Patrick.
That's all for the state, Your Honor.
All right. Petey
Yes.
Kemp?
Yes, Your Honor. My client is 30 years old. As Mr. Franklin Clarence mentioned, my client works at Northside Hospital as a nurse. He has a bachelor's degree and he has been very professional. This is his first arrest ever. And Your Honor, it was my client who called the police. So we would like to request for a signature on bond, even though my client strongly prefers to have a no further violent contact. I just want to make sure you understand that the house is actually his house. He's the one who's paying for the mortgage. His name is on the deed. And according to my client, Mr. Franklin comes in and out and he stays with his parents. So we would like to make sure that my client can return home. Thank you.
Okay. I will go ahead and order the $3,000 surety bond. There hasn't been an ample cooling down period yet. I'm gonna order stay away from 5561 Sable Way. No further contact with the victim, Mr. Franklin. And
Yes,
no
ma'am.
drugs.
Sorry. I currently am here at the address because this is where I was at as of last night, but I can leave right after this call, I guess. Because my stuff is here, my clothes, and
Well, we would have to give you time to get all that out. I don't know.
yes,
He has a surety bond, so I don't know if he's gonna get out today or tomorrow. Or when. But normally if I have the defendant to have to stay away, then you can stay there. But if you're going to be moving, he'll just have to ask his attorney to do a bond modification to allow him to live there once you are gone. But it's hard to monitor that, and I don't want to give an order that's conflicting for someone to follow and not get arrested.
Excuse me, I misunderstood. Did you say surety or do pretrial?
I said surety, I believe. Or
Okay.
did I not?
I heard surety, but
Okay. Yeah, I thought I said 3,000 surety.
Okay.
Mm-hmm.
Your Honor,
And I guess right now is discussing about the stay away. And the victim then interrupted me and said that he was going to be moving. So I don't normally do this, but Mr. Franklin, when would you be clear of that home?
I mean, if he's getting released by today, I could pack up my stuff in my car. It may take a trip or two to get my stuff out of here, out of the car, or in my car to get my stuff out of the house.
And Your Honor, I just want to clarify with Mr. Franklin that he's under no obligation to leave the residence if he does not wish to. What I don't want is for Mr. Franklin to think he has to vacate the residence.
Correct. Thank you for that. Yeah. You are the victim in this case, so we want to protect you first, make sure you're going to be safe wherever you're residing.
Yeah, I don't feel I won't be safe like around him at all. Like I don't feel that at all from him. He's never made me feel unsafe.
Well, but I don't want you there together.
Yes, ma'am.
That
Yes,
is
ma'am.
what I'm not ordering that. So
Or yes,
one
Your
of
Honor.
either of you must go. And normally it's the defendant that must go.
Well, this is his house, so I personally don't feel right, I guess, kicking him out of his own house. I'd rather take myself out of the picture of his house, because it is his house with his name on it. So I just want to make that clear that I am willing to step out of his house to honor what you're asking.
Your Honor, perhaps to facilitate this, if I may. Mr. Franklin, how long do you think it will take you to leave the residence?
Give me less than 5 hours, 6 hours.
Okay.
No, I wouldn't do that to you.
Your Honor,
I'd at least give you 24, 48. Yeah, I wouldn't.
My suggestion is that the defendant may retake the residence on Monday, August 28th, which gives Mr. Franklin 7 days to remove his items. So it's not a rush job for Mr. Franklin. And then the defendant, if he bonds out, can retake residence if he wishes.
Yeah, I think that's a good suggestion.
Question, Your Honor.
Yes.
Does that mean, I guess, Patrick will be staying in prison till the 28th, or is he able to come back to his residence?
You're a little fuzzy. Say that again.
Oh, sorry. I was saying, does that mean, I'm just not understanding, is Patrick able to come back home to his residence after he's bailed out? Or
No, what? Not as long as you're there. No. So he can't come back
I
with
can
you
definitely
there.
have my stuff. I would
And we
definitely
were
have my
giving
stuff
you,
out by
ample
today.
time. Because
Yes,
what we
ma'am. By
don't
today,
want
I
to
can have my
happen,
stuff out of here.
right? What we don't want to happen is for him to bond out or get out and then return there and you trying to move. And we don't want any additional incidents or things to happen. Because you all are ordered to stay away from each other, have no further contact.
Okay. Or is it no contact at all, or no violent contact?
No, I said no further, no contact at all. There hasn't even been the ample cooling down period at this point.
Y'all, number 18, Mr. Williams.
I think what we're going to decide to do, because I hadn't said no further drugs, no drugs, alcohol, weapons, or guns while on bond. And we'll give you, if you want a shorter period, I can make it till Saturday or Sunday. Just making sure what date we're going to put in this order from Ms. Bridgewater. What if you don't want all the way to Monday, that's fine, but we'll give you that. What date would be fine with you?
Are you speaking to me, Your Honor?
Yes.
You said Saturday or?
All right, Saturday is the 26th.
Is there any way I could do sooner? Because I know he could work.
I mean, you can go sooner. So by the time the defendant gets there on the 26th or 27th, it'll be obvious and hopefully clear that you have moved out all of your belongings.
Okay.
I mean, you don't have to wait to that date. We're just giving you the extra time. Something may come up. You might not be able to rent a truck or use a car. I don't know how much stuff you have. So we're just giving you those
Yes, ma'am.
extra
Or
days.
yes, Your Honor. Yes, Your Honor.
Okay. So we'll give you to
Because
Saturday.
I know
the
he works, and that's my main concern. It's just him not being able to work.
Okay, we'll give you to Saturday the 26th at 12 p.m. midnight to vacate the premises or sooner. And but it's still no further contact. And the victim is going to vacate. So I'm sorry.
Would I at least be able to bail him out still? Or
I
like
can't
without
give you that kind of
contact?
advice.
Okay.
I can't give you that advice, but if you have contact, you do run the risk of him going back to jail.
Mr. Franklin, Ms. Cheney will be more than happy to explain this to you after court. She
Okay,
is here on
thank
this
you.
Zoom and she can speak to you directly, but we do need to move along. I apologize.
Okay, thank you.
All right, thank you.
Position number 18, Ms. Williams.
23 CR 005143E, James Williams, charge of
One last thing, I'm so sorry. So that was a $3,000 good bond, am I correct?
That is correct.
Okay, thank you.
Mm-hmm. And the move out date is 8/26 at midnight. So the defendant cannot return until after that date. All right, Mr. Williams, in charge of 1 count of battery, family violence, and 1 count of cruelty to children, the third pretrial.
15 cycles. Last arrest, January of 2015 for a probation violation. 2015 probation violation for battery. 2015 conviction for battery. Then 2002 theft by receiving stolen property. Then 3 driving while license suspended or revoked convictions, all in the 90s and 1 in 89.
Okay, state. Oh, you're muted, Deputy Falk.
Apologies. This happened August 20th, 2023 at 14 Meldon Avenue. Officers spoke to Leslie Cooper, who told the officers that the defendant picked her up and her 2 minor children, LC and DM, from a baseball park because her car ran out of fuel. And the defendant was supposed to drop them off at home, but instead took him to his home at Meldon Avenue. When she confronted him about it, he became irate, pointed his finger in her face, which made contact with her forehead. He then grabbed the back of her shirt, leaving a long scratch mark from the right side of her neck to the small of her lower back. This incident was witnessed by DM age 7 and LC age 8. We did have an opportunity to speak with Ms. Cooper. Ms. Cooper informed us that she and the defendant have been friends for approximately 19 years and lived together for 7 years. She stated that they had a case around 2011 out of Clayton County. She did confirm the events on the warrant and stated that she wants to have contact. However, my concern in this regard is that the defendant has a 2015 battery conviction, and he actually has an open case out of Clayton County. That case number is 2023 CR 0617. That is a simple battery family violence and a battery simple battery case where he was bonded out in March of 2023. This incident happened approximately 5 months after he was bonded out on his open battery case out of Clayton County. We did confirm with Clayton County that case is still open. For that reason, the state's recommendation is a $4,000 surety bond, $3,000 on the battery, and $500 on each of the cruelty to children charges for a total of $4,000. I know that the calendar is showing 1 cruelty to child. It is in fact 2. I have forwarded the additional on the other cases where there were additional charges. I have forwarded the accusations and witness list to Ms. Bridgewater and Mr. Jordan, and I will do it so again on James Williams' case. That's all for the state. We would like to sound for Ms. Leslie Cooper.
Ms. Leslie Cooper. Leslie Cooper. All right, go ahead, PD Kim.
Yes, Your Honor. My client, Reverend Dr. Williams, is 67 years old, and Your Honor, he completed his divinity PhD at University of Metaphysical Science in California. He got his PhD on 2011, Your Honor, and also he is currently enrolled in another college to get as a full-time student to get another degree, Your Honor. And also August 23, which is tomorrow, 5 p.m., he starts his new job near airport. So he has to go and pick up his badge to start working. So we would like to request for a signature on bond for him to be released and start his work. My client denies the allegation, and Your Honor, he feels like he was showing kindness to Miss Leslie Coopers, who was homeless, who had no place to go as a single mom with the 2 children. He was showing kindness. The place is actually for a lot of senior citizens who reside there, and he has a ministry to serve the homeless, and he feels like he is attacked by he kind of backstabbed, and he feels like his kindness was returned with willful illness. So we would like to request for a signature on bond. My client has no desire to have any contact with Leslie Coopers, and that location, 14 Meldon Avenue, is his place. So we would like to request for him to stay there. Thanks.
And Your Honor, if I omitted and asked for a stay away, that was incorrect. He does reside at that residence. We are, however, asking for no further contact with Miss Leslie Cooper and her 2 minor children due to the lack of cooling off period in this case.
All right, and then what was the breakdown again?
That is going to be 3,000 on the first count, 500 on the 2 cruelty to children counts. And I am sending that documentation to show the 2 counts of cruelty to children over to Ms. Bridgewater and Mr. Jordan.
Okay, good, thank you. All right. I'm going to order that $4,000 surety bond, 3,000 on the battery, 500 on each of the cruelties. So that'll be a total of 4,000. No further contact with the victim and her children. And no drugs, alcohol, weapons, or guns while on bond.
Your Honor, position number 11, Mr. Johnson.
This is Ms. Bridgewater. Oh, I see it. 23 CR 0051338E. Mr. Johnson charged of 1 count of stalking, 2nd count of harassing communications. Pre-trial.
Yes, 4 cycles. Last arrest was June of 2022 for aggravated assault, simple battery against a police officer, terroristic threat, and willful obstruction of a law enforcement officer. He currently appears to be on probation for simple assault and willful obstruction of a law enforcement officer, 22 SC 183919. The disposition was January 24th of this year, 12 months probation. He has an open simple assault case, 21 CR 005469E, and then an open simple battery family violence, 20 CR 004258E, and nothing further.
Okay.
Your Honor, if I remember correctly, I believe this is the one that PD Ebden actually requests for a breakout room.
Your Honor, if that breakout is based on the facts of this case, the state would object. If it's based on an MHET, then we can address that in a breakout.
I thought I only had 8 and 13.
That's why I'm asking, Your Honor. I have a feeling this is not based on MHET issues. Well, it may be actually.
Is it?
So
this is not based on the facts of the case. I would ask for a breakout room to discuss the client and or while this is not recording.
And Your Honor, I think
do you
that's
want to
due the
just stay
facts
in
of the
open?
case.
Yeah, do you want to stay in open court and just turn off the recording?
Well, the state would be agreeable to turning off the YouTube, but not the recording.
I
since
mean,
we do want
I
this
meant to say
preserved for
that
the record.
vice versa. No, I
Understood,
did.
Your Honor.
I said it back. I said it backwards. To turn off the YouTube and not the recording. Is that sufficient?
I would prefer a quick breakout room if that's okay.
I'm not sure if it's warranted.
Your Honor, if we could go into the breakout, and if it's determined that this is based on anything other than the facts of the case, the state will ask to come out of the breakout and go on the record.
All right, Miss Champion.
Can I be included in that breakout session? This is Attorney Thomas, please.
Oh, hi, Attorney Thomas.
And if ASG Ferguson could be included too, I would appreciate it.
Got them.
Thank you.
And ASG Elon.
If everybody else is going, I thought I'd.
I said we might as well go. Let's everybody go.
Okay, right.
No, that's the whole purpose of it. Are they doing all the breakouts at once? Or just his? That's all.
They usually do them all at one time.
Thank you, Jesus.
Usually.
All right, we're back on the record. I will give the bond on position 8, which is Janicia Hightower. That's going to be a $1,500 surety bond. And BHET is ordered. And a stay away from 911 Joseph E. Boone Boulevard. You gotta stay away from there, Miss Hightower, or else you'll be right back here. We're going to order no drugs, alcohol, weapons, or guns while on bond. So $1,500 surety bond. All right. All right, thank you.
In courtroom 2, if we could just get through the rest of the calendar and reserve Mr. Johnson's case for later, I did make that request to the court and to courtroom 2.
I heard you, Ms. Falk. I got you. We got position 13 coming up, Mr. McGirt. Mr. McGirt.
Ms. Champion turned off the YouTube for me.